Kevin Sharp, I've known you for about 25 years. We've had quite a run. Now we are named partners in the firm Sanford Heisler Sharp McKnight. Tell me, when you think back on the history, what you remember when we started 25 years ago.
Well, it's hard for me to remember back that long, but it actually doesn't seem like 25 years. We have to think about it to know, holy cow, it has actually been 25 years. Yeah. Where did time go? It flew by. Because you remember, you contacted me about being local counsel in a discrimination case against Whirlpool.
So you were in Nashville.
I was in Nashville,
I
Tennessee.
was in Washington,
I had a
D.C.
small solo practice. I may have had another lawyer or two in, but I had gone out on my own. I'd been doing defense work coming out of law school. I'd gone to work for Congress for a couple of years. I'd come back doing defense work and decided that was not where my heart was at, that I wasn't enjoying it. I didn't like what I was doing and how I was doing it, and thought that the remedy for all of this and why I had decided to become a lawyer to begin with was to help people, represent individuals. And so I left the law firm I was with and went out on my own. Eventually built that firm up to 12, 13 lawyers. But that's where I was at that time.
What was your practice at that point? You started on your own.
I came out doing the plaintiff side of what I'd been doing defense work. It was employment litigation. It was civil rights work, a lot of discrimination, sex harassment work. I was one of the few in Nashville who was doing disability work, representing individuals in Americans with Disability Act cases.
And that started when?
That started in 2002 is when I left my firm.
You've been doing this work for about a quarter of a century.
Yeah.
And I contacted you roughly soon after you started, right? I mean,
It wasn't long. Yeah, maybe a year. Maybe a year or so after that.
And we were involved in a race case against Whirlpool.
Right.
And we had a class action race discrimination for African Americans, but also a class action for white employees at Whirlpool.
Right. It was one of the things that had happened. And what we discovered as part of that investigation is that there were white employees who were coming out, opposing the way the African-American employees were treated in the workplace. And they were in some ways, retaliated against even more so than the others. And I think the mentality was that in that place, and in some ways in that part of the country, if you were a white employee standing up for African-American employees, you're somehow worse. This is more of a betrayal. One of the worst things you could possibly do. And so the environment for them was incredibly tough.
And we wound up trying a case together in Nashville, in the court you eventually sat on. We'll get to that in a minute. But what do you remember about that trial?
I think one of the things that impressed me the most, and I still think about, is how hard all of the lawyers and staff with your firm at that time worked on that case, that it was all-consuming and seemed to never stop. Everybody was there. Everybody was excited about what was happening. Everybody was passionate about these issues. And that I still think about that. And I think one of the people who worked on that case as a legal assistant eventually went to law school and became a partner in this law firm. So that's the thing that sticks with me the most, is just how passionate the people were.
What I remember most about that trial is actually working with you. And I don't know that I've ever shared this with you before, but I remember preparing. You were local counsel, and you worked so hard and did so well on that case, as you do in every matter. But I remember staying up all night the night before my closing. And I remember I don't remember who else was there, but I remember your being there. And I remember your helping on that close into the very wee hours of the morning. Do you remember that?
I do remember that. I think it was about 2:00 in the morning, and we're still working on that close. And it was such a great closing, and really captured everything that had happened over the course of that trial.
well, a lot of it goes to you because I remember the hard work you did in helping prepare for that. So we did that trial. That trial was about 07, 08.
Mm-hmm.
We continued working together on some matters. And next thing you know, you call me and say, hey, I have this great opportunity. Do you remember that conversation?
I do. And that was just a couple of years later. We tried that in 07. By 2010, I got a call from the White House saying we're considering you. Actually, it wasn't the White House. Sorry, I got a call from DOJ. The first call eventually was called by the White House. The first call was from the Department of Justice saying the White House is considering you for this open seat in the Middle District of Tennessee. We need you to, if you were interested, you need to let us know, let the White House know, and let's start vetting you, because it's a lengthy process, and it's not just the confirmation hearing. The White House has got to figure out whether or not you're the right person for that job. And it's interesting because if you remember, President Obama had been elected in 2008, and I didn't get the call until 2010, and this seat had been open for years before that. It was open when President Bush was in office, and they could not get it filled. And one of the things that had us so excited about President Obama coming in was all of these judicial seats that had been sitting vacant. He's coming in, he's got a plan, and he's got this type of person that he wants to fill these seats. And then he ran into the buzzsaw of an opposition party.
Well, despite that opposition party, as I remember it, and correct me if I'm wrong, you were someone that went through confirmation and you were confirmed 97-0. Am I right about that number?
The number is a little off.
It was
a little off. It was 89-0.
89-0.
There were some folks
I knew there was a zero in
it. There was a zero. There was no
which is
opposition.
amazing, because how many times has that happened ever since, right?
Right. And it wasn't happening then. It was really difficult. And it was one of the things that we talked about with the White House as part of the vetting process and part of the investigation was my ability to have everyone comfortable with me and excited about me taking the bench. And it was really it was not something that I'd sat around thinking about before, but it was exciting and felt good to know that both sides of the aisle thought I was appropriate for that.
And you had, Senators Corker and Alexander behind you?
Two Republican
senators.
Yeah. And so both of them were supportive of me and, were able to help get me through the process.
And what a great story that is, too, with a firebrand like President Obama coming in, a Democrat, and two Republican senators in a very red state going with you and orchestrating your confirmation with the zero opposition. It's a great tribute to you, and it's really a great tribute to the process as it existed back then.
Right. I mean, unfortunately, it doesn't exist that way anymore, but it worked, right? And it worked because that's the way the judiciary is supposed to work. There's a reason that it takes so long to get through, although I was able to do it in about 9 months, is because they want to make sure that you are filling these seats. This is, a co-equal branch of government that has a real duty to perform, and they want to make sure they're filling those seats with people who have the intellect and the temperament and the judgment to sit there and make these most important decisions in people's lives. And so it was a tough process.
So I remember just taking a step back before that, though, talking with you about your options, because as it was presented to you by the government, they wanted to know whether you might be interested in taking a position on the district court, but also on the Sixth Circuit Court of Appeals. What was your consideration there?
That's right. There was also a seat open on the Sixth Circuit, and those are two very different. They have two very different roles to play in the system. And I really felt like in my career to that point had been one where it was the closest to the people, the closest to the lawyers who were going to be there, the closest to justice for these individuals, instead of elevated to the next level where you're working on panels of 3, the issues are different. You look at them differently, and just didn't seem to fit my personality. And they actually came to me again later after I'd been on the district court asking if I would be interested in being elevated to the Court of Appeals. You can sit by designation. So what that means is when the Court of Appeals needs help, they can elevate district court judges temporarily, and they'll sit by designation on cases. And so I'd done that on about a dozen cases. And so I knew how the system worked up there, and really felt like the place for me to be was at the district court.
So you were on the district court from 2011 to 2017, 6 years. You were elevated to chief judge 3 years in. So you served with distinction as chief judge for 3 years. What do you remember most about your 6-year experience as a trial court judge?
A couple of things. One, I tried to be a judge who was a lawyer's judge. You want to get at the right answer, but you also want to do it in a way that helps the lawyers present their case and is not too. There's no reason to be too difficult for that. And so, one of the things that I remember is how hard the lawyers worked, how reminded me how tough a job that was, although I hadn't been up there long, and how the judge really has the opportunity to make this process smooth and get to the right answers, get the judge to get the case to the jury so that we can get there and do it in a way that's not overly burdensome on people. But the other thing that hit me was how difficult the criminal side of it was, not the law. The law actually can be easier. There are about 5 things in criminal cases that you really need to get right. But this is where the rubber meets the road on the Constitution. This is where liberty is at stake, right? This is what the Constitution is about. Constitution's not there to make sure that people are making enough money. The Constitution is there to make sure that people's rights aren't being trampled on, that no one is deprived of liberty without due process and with equal protection. And that's where I became very concerned with what I saw. I saw a system that seemed to grind people up, particularly people of color. It was overly harsh. It was a system where Congress, the other co-equal branch of government, had abdicated its responsibilities and wanted to give the judiciary what should have been the Congress's role. Here, we've got a mess on our hands, fix it for us. And your tools to fix it as a judge are very limited, and it's mostly incarceration or in those instances where you can do it with some other form of punishment and try to craft that. But it really was about sending people to prison. And I'm not saying that there weren't people who had committed these crimes. They had. But what I wasn't able to do, what the judiciary is not able to do, is to fix the why. By the time a 25, 35-year-old person comes to me, African-American male in an orange jumpsuit, there's nothing that I can do to fix that problem. And it became very frustrating to me. Addiction, mental health issues that seemed to drive this process. And I just had to watch it happen. That became very frustrating to me. And sentencing, to determine a sentence was hard. And for someone like me, it really ate at me. And I would spend not just hours, but sometimes days and days before a difficult sentencing coming up, just agonizing over what's the appropriate sentence.
So you had a very difficult sentencing, a very high profile and public sentencing as it is now. Tell us a little bit about what happened with Chris Young.
Yeah, so the catalyst was, you agonize over these sentences, but then there were times where it's actually worse, and that is when there are mandatory minimums. You don't have a choice on what the sentence is. And there was a large drug conspiracy case that came to me, 32, 33 defendants, and involved a gang. But as part of this conspiracy, he wasn't a gang member, and he was really not a major player. He was a very minor player, in fact, in this conspiracy. He did what they had accused him of doing. But because of the 3 strikes rules, if convicted, this young man had to go to prison for life. And in the federal system, life is without parole. There is no parole in the federal system. So when he was convicted, he was going to prison for life. And that to me made no sense. Here was a young man who had potential. Here was a young man who had every disadvantage, and found himself in this spot. Sending him to prison to die was not justice. And that's what, when I talked earlier about going through that system, that's what all the vetting was about. That's what the FBI investigations of me were about. That's what the Senate confirmation hearings are about. Can I dispense justice within the bounds of the Constitution? Obviously, they thought I could. There was no one who voted who didn't think I could. And then they took that away from me and made me sentence Chris to life without parole for a nonviolent drug offense. And that was really the catalyst. Then my phone calls to you, which are, I'm not sure that I am able to do justice. I'm not sure that we're doing justice in this system, and that maybe I should step down and come back.
And you decided to do just that.
And I did that. I would not have done it but for our conversations and this law firm, right? Because I could have stepped down, but I also could have stayed and continued to complain about what we were doing, do the best that I could to ensure that justice was being done. And there aren't a lot of law firms like this one.
So you could have, as a sitting federal judge with 6 years on the bench, you could have gone to any law firm in America. Why come to this law firm?
Because this was the law firm that had a passion for the law, had a passion for justice, was a place that would embrace the way that I think and feel about the law and about people. And I didn't find that anywhere else. And I think had there not been this law firm, I probably would have stayed. And there are law firms out there, go join one of the big law firms, and they'll pay you and you show up every day with your tie and your briefcase. But is justice really being done? Are people being helped? And I think the answer is no. And the only place that I saw, and where I liked everybody, and they had the same passions that I did, was Sanford Heisler.
So in the world of strange connections, you have Chris Young, you have Kim Kardashian, and you have Donald Trump. How do you connect those three people?
So the next thing that happens is when I joined this firm, and as you well remember, and other people agreed, look, we want to let Kevin do what is passionate, where his passion is, follow that. And something very wrong had happened while I was on the bench with sentencing of Chris Young to life without parole. And so it became important to me to try and remedy that. And the way to do that was work on clemency, see if we could get the president to grant clemency to Chris, because it was the only way this young man was going to be able to re-enter society. And I recognized him, as from my time trying his case, that this was an asset, not a liability. This was someone who could benefit all of us. And so the goal became, let's get Chris out. And the only way to do that was through the president. And Kim Kardashian had seen and heard this story and became involved and was able to get us a meeting with the President of the United States, where I could sit in the Oval Office across from that desk and say, Mr. President, here is why Chris Young and others like him, but in this case, Chris Young deserves clemency. And that was in September of 18. And before President Trump left office, he signed the papers. And his order granting clemency, it was time served. This was not a pardon. Chris had done what he was accused of doing. It was clemency to time served. The order that releases him is not the usual press release that says, here's who I'm granting clemency to, name what their crime was. It was really a significant chunk out of a letter that I'd written to the president advocating for Chris, and it became part of the White House's press release on why Chris Young was going to be released. And Chris he was granted clemency within a few weeks. He was home. I was able to meet him at the airport when he was returned to Nashville. We've stayed very close since then. He came and spoke at the courthouse when my portrait was hung in the federal courthouse in Nashville. It was the first time he had been in a federal court since I sentenced him. So
That is a great story
Yeah.
and a great success and a great tribute to your passion and to your vision as to what you wanted to do on the bench and what you could do off the bench.
And as the kind of last piece to that story, Chris graduates from college on May 16th from SMU, and I'll be attending his graduation ceremony.
You talked about the passions that you had before taking the bench, the concerns you had while on the bench, and the reasons you stepped down to join this firm. One of the passions that you've demonstrated throughout is your passion for justice, which takes many different forms, one of which led you to Leonard Peltier. Tell us about that.
Well, to step back just a little bit on what drives some of that passion is 3 times in my life I've taken an oath to support and defend the Constitution of the United States. I took that oath when I joined the military. I took that oath again as you did when we became lawyers and were licensed to practice law. And then I took that oath again when I was on the bench, when I became a federal judge. And so that oath to support and defend the Constitution of the United States against all enemies, foreign and domestic, really means something to me. And so when I saw those issues while I was on the bench, it really tugged at me. And when I stepped down off the bench and had an opportunity with Kim Kardashian to meet with President Trump, that became a big story after our meeting, not because I was in there, but because Kim Kardashian is at the White House again, meeting with President Trump. Someone in Texas read that article, and that someone was Willie Nelson's ex-wife. And she read that article, and she'd been a supporter of freedom for Leonard Peltier for decades.
So tell us who Leonard Peltier is.
So Leonard Peltier is a Native American activist. He was a member of what is known as the American Indian movement. Really started in the late 60s, early 70s as a movement, not necessarily an organization, but as a movement to bring Native American issues to the forefront and get those in front of the government. He was a member of that movement. And in the mid-1970s, kind of you saw this, if you go back to the Alcatraz, and people have heard about the Native Americans taking over Alcatraz, and they were there for a year and a half. You also had Wounded Knee in 1973. The American Indian Movement organized an organization. They went into Wounded Knee. It became a battle. People were killed. It was really a standoff with the FBI and federal marshals. People were killed. That was in 1973. In 1975, there was another incident involving the American Indian Movement members and FBI agents, and 2 FBI agents and a Native American were killed in a shootout at Pine Ridge Reservation in South Dakota. 3 Native Americans were indicted for the murder of these 2 FBI agents. No one ever even bothered looking into who killed the Native American boy. Leonard was one of those 3. They were tried separately because Leonard had fled to Canada. His 2 co-defendants were acquitted based on self-defense. And so that only left Leonard Peltier. Leonard, through violations of the Constitution, was extradited from Canada and brought back to stand trial. His case was moved to North Dakota, and he was tried in front of an all-white jury, one of whom admitted by day 2 that she was prejudiced against Native Americans, and she was left on the bench. on the jury. And so Leonard was convicted. He was the only one convicted. Now, part of that, part of the evidence, really the only evidence against him, was a shell casing, which the government said was tied to a weapon that he had been seen with. And that was it. Their entire case was, here's a shell casing. It is the same type of casing that would be used, or the same casing that would be used with this type of weapon. And they put an expert on the stand who said, if we could have done a firing pin test, we could prove that it was his his weapon, but the weapon that we believe he had been destroyed, and so we can't do a firing pin test. This is what we've got. And basically that was the evidence against him.
Highly speculative.
Highly speculative, and it turns out they had done a firing pin test, and they knew it wasn't his weapon. It was not the same weapon. But on appeal, he was represented by Bill Kunstler, famous civil rights lawyer, and Bill brought that up to the Eighth Circuit Court of Appeals. And what the Eighth Circuit said was, the law was different at that time than it is today, that the Eighth Circuit said, we can't say for sure that had this evidence, exculpatory evidence that tends to prove you did not do the thing the government accuses you of, we can't say that the jury would have done something different. They might have said he was an accomplice. And so his conviction was upheld. All of that happened between 1975, when the shootout took place, and 1977, when he was tried, and Leonard was still in prison. By the time Connie Nelson, Willie's ex-wife, wrote me a letter and sent me files related to Leonard Peltier's case. And so by summerish of 2019, I receive a box. And in that box are trial transcripts from Leonard's trial, newspaper articles over the years, paintings, because Leonard had taught himself to paint while he was in prison and had become a fairly well-known artist. The opinions from the courts at the district court and the Court of Appeals. And I read all of that for the first time. I mean, I didn't really know the story of Pine Ridge and what had happened there. I knew the story of Wounded Knee because it was every night on the news at that time. But I didn't really know this story. And so I had no preconceived notion of what happened in the trial, what happened that day at Pine Ridge. All I knew was, here's this box, and I just start from day one and start reading the transcript like a script. It's And what strikes me is I'm reading that because I haven't been off the bench long as a federal judge, as someone who may have been sitting on the Sixth Circuit Court of Appeals, as someone who did sit in multiple criminal trials, dozens and dozens of criminal trials, and seen hundreds of defendants. I read this case with that mindset. And as I read it, back to my oath to the Constitution, it really upset me that why, nearly 50 years later, is this man still in prison? This should not have happened, and it should have been corrected somewhere along the way. And so I contacted Connie and said, I'm in. If Leonard wants me to help him with this, I'll do it. Now, that, somebody told me at the time, I mentioned to someone I was doing it, and this guy said to me, why do you always pick up the heaviest rock in the quarry? You are never getting this guy out. This has been nearly 50 years. He is a symbol for some as to the criminal element in this country and the radical Native Americans who need to just be thankful they live here. And then he's, on the other side, a symbol for those who say this is symbolic of everything the United States government has been doing to the Native American community. You are never going to be successful here.
So, spoiler alert, you were successful. Let's fast forward to how you did it. You were instrumental in helping get Leonard Peltier free. How did that happen?
I think that happened because by the time I get it, we're decades in. Most of the people had been big supporters. This was a national story, an international story, really, through the 70s and through the 80s. But his supporters had been dying. He was now, a late 70s old man in a maximum security prison in the federal system. People had forgotten about him. And I think what we were able to do was, one, keep it alive, keep the story alive, but repackage it, not to change the narrative because the facts were what the facts were, but to tell the story in a different way. Because several things had happened to change the mindset. The country had moved. And one of the first catalysts that got the country at large to start thinking about Native American issues was Standing Rock. And we had been seeing that on television. And then we learned about Indian boarding schools. Native Americans had known about those, for 100 plus years, but it wasn't in the mainstream of the American conscience that the government had created these boarding schools with the motto being, kill the Indian, save the man, where they would cut their hair, forbid them from speaking their language. Leonard Peltier had been kidnapped as a 9-year-old, along with his 6-year-old sister, and taken to one of these schools where they weren't allowed to speak to each other, where they could not speak their native language, their Ojibwe. Most people know them as Chippewa, out of North Dakota, and they were beaten. And so the American public learned about that. And so it wasn't the facts that changed, but the audience changed, and they were ready to hear about that. We were hearing more about treaty breaches and the way that the United States government had treated Native Americans, and that clicked.
So take us through the process, though, of specifically, you read these documents, you're familiar now with the facts, you're outraged by the constitutional violations, by the criminal procedure violations, you're looking at it through the lens of a judge. How do you get from there to the point of representing Leonard Peltier and being instrumental in securing his release?
Well, so that's the phone call back to Connie that says, I've read this. Holy cow. How is this still going on? Why are we still here? Look, if Leonard wants my help, because I think at that time she had spoken to Leonard, but Leonard was kind of like, another lawyer. We've been doing this for 4 decades.
And Connie is Willie Nelson's
wife. And so she puts the two of us in touch, and I talk to Leonard, and, I tell him the way I feel about this, the way I think that the world is ready to hear his story, and the way that they weren't before, and that this story is so much more than about Leonard Peltier, because he is a symbol for all that is wrong and how we got to this place. But he's also a human being who's been living in a 9x12 cell for 50 years, and maybe initially it was like, okay, at least there's somebody willing to help me, but I think that Leonard was also excited that here's somebody else ready to pick up this mantle. And I see it differently than everybody else has seen it in the past.
But there were people who saw it the way you saw it as early as certainly the late 90s, when Bill Clinton is about to leave office, has papers on his desk on his way out the door,
right,
literally, and he doesn't sign it. Why doesn't he sign it, do you think?
Well, that's right. And I've spoken to the lawyer that represented Leonard at that time, and he told me he got a call from the White House the night before President Clinton was going to leave office. It said the clemency papers for Leonard Peltier are on his desk. He's going to sign them tomorrow before the inauguration. Leonard's going home. And that was his administrative assistant who made that call. And then he did not do it the next day.
Do we know why?
We don't know why. I think I know why, trying to piece it together. Who met with whom? I've gone back and looked at White House logs, trying to figure out who went in. I've talked to people who've talked to people. And in some sense, trying to figure all that out, we'll never know for sure.
What's your best guess?
My best guess is that he listened to the people who were concerned about what that might mean to the Democratic Party. President Clinton was concerned that if he did this, it would, in spite of all the violations, in spite of the justice, in spite of the Constitution, that politically it was not good for the Democrats.
Fast forward 20 years, what happens?
Well, so we try this with President Trump. On the president's last day, we are in indirect conversations. I'm talking to people who are talking to people in the White House with Ivanka, Jared, 2 different people. They're each on this. And I think that President Trump may sign this and recognizes, his own rhetoric about the conduct of the FBI and federal agents and, the way he feels about them, that he may get this done. and may sign this. And right up until about half an hour before the inauguration, we're talking to them, and then phone calls stopped getting returned. I went, okay, well, that is not going to happen.
So it didn't happen. 2020, January 2021, President Trump then leaves office after his first term. President Biden takes office. What happens during the Biden administration?
So, this was one where a lot of people, again, wanted to give up. It was like, okay, we're not going to get this done, right? This is a waste of all of our time. And, what I said to people, and some did kind of float away and were gone, but the core stayed with us, particularly the lawyers at this firm, the staff and young lawyers who wanted to work on this case. We just got to stick with it. Until it's over, it's back to Yogi Berra. It ain't over till it's over, and it wasn't over. And so we repackaged it again. And this is, back Standing Rock, boarding schools, and President Biden understood the importance of Native Americans. He felt that injustice and recognized the injustice that had happened for 400 years. You couldn't really understand what happened at Pine Ridge in 75 without understanding Wounded Knee in 73 or Wounded Knee in 1890, or let's take it back to landing at Plymouth Rock or, the first Thanksgiving. You had to understand all of that and have a sense of history and how we got here so that you didn't give up on Leonard Peltier.
A lot of people had that sense of history, and a lot of people shared the sensitivities, including perhaps people in the Bureau of Prisons with whom you were in communication. But despite those communications and despite that sensitivity and despite that allegiance, it didn't happen month after month, year after year in the Biden administration. And there might have been some interference by the FBI. What do we know about that?
Well, one of the things that had made it difficult was if I take this back to our practice of law, right? If I'm filing a motion and the judge gets my motion and the other side gets to go back into chambers without my knowledge and argue against my motion, and then the court rules against me, I have no idea what just happened. I don't even know that the other side got to go back there and have these ex parte communications. It was a lot like that with the White House. I could file my papers seeking clemency, but I didn't have the access where, the head of the FBI or the Attorney General could, get a meeting with the president and argue against this. I don't know what they said, so I can't even refute it. In this case, I did find out what the FBI said. I knew it was happening, but, not for sure. And I didn't know exactly what they were saying. And I got a call from a reporter who said, have you seen this letter that Chris Wray, who was then director of the FBI, wrote to the president opposing clemency for Peltier? And I don't know what you're talking about. So she said, well, she had gotten a copy of this letter that Ray had sent from a member of the FBI who was convincing her to stop writing, this was Jennifer Bendry with the Huffington Post, to stop writing positive articles about the Peltier case because you don't know what you're talking about. Read this letter from Ray. And so she sent me Ray's letter, and I'm reading that letter and going, well, look, even the FBI knows this is not true. There's nothing in this letter that is accurate. All of their arguments, they abandoned decades ago that they had evidence he shot them, when in fact, at the Court of Appeals, the lawyer arguing on behalf of the prosecution against Peltier admitted, we don't know who killed these agents. And yes, there was this ballistics test that showed it wasn't his weapon, but, so what? All of that, well, they've abandoned that over the years because we now know what they did and how they got there and the lack of evidence. And that was what he had put in his letter again. It was like, well, this is ridiculous, but I wouldn't have known about it to go in and be able to respond to it. Now, one of the things he said was, oh, but wait, he admitted that he murdered 2 FBI agents to another witness, and she is sworn under testimony that he said that to her. And they cited a case for it. And go, well, that can't be right. What is this case? Case had nothing to do with it. That's another one where the White House is not going to go site check them. Case had nothing to do with that, but that was their footnote. There was a witness in another case 27 years later who got on the stand, unrelated to the Peltier case, and said, oh, by the way, Leonard Peltier told me he killed those agents. And so that's what they were using. Unrelated. Nobody cross-examined her about it because why would they? It has nothing to do with our case. I'm sure most people were surprised that she even said it.
So what do you think is responsible for all
But
this?
wait, there's one more piece to that, though. What the other thing that is not mentioned in there is that she was dating the lead investigator and ultimately married the lead investigator of the Peltier case.
Well, there's that.
I mean, right, there's that. Yes, you identified her as the last name Nickel, but she's going to be married, and her name is Ecafee, and the Ecafee is the investigator in the Peltier case. The whole thing was contrived, in my opinion.
So I have a long-standing principle in life, and the principle goes like this. If someone says something that makes absolutely no sense, always look for an alternative explanation. You have, in this case, rampant constitutional violations, criminal procedure violations, and stories that just don't add up. Given that, something else is going on. Assuming I'm right about the principle, something else is going on. What do you think that something else is?
I think that something else is that the FBI considers themselves a family, and 2 FBI agents were dead. Now, so was a Native American, but 2 FBI agents were dead. And they really did not care that they had the person who caused it. They had someone. And that was good enough. And he was also on the kind of enemies list, because one of the things we didn't talk about was COINTELPRO, Hoover era program, where the FBI run counterintelligence against Americans, right, in violation of the Constitution. And one of those groups that they considered subversive was the American Indian movement, along with the Black Panther movement, along with unions, along with anyone who was involved in social justice issues. They were enemies of the state. And so they considered the American Indian movement as part of that. And so you had 2 agents who were dead. And it is a tragedy. They were 2 young men who I think were put in that position because higher-ups in the FBI wanted to provoke a problem.
Also a tragedy, as you mentioned earlier, that a Native American boy was killed, no investigation
No
there.
investigation, that's right. He was shot in the head. Joe Stuntz was his name. He was 21. Nobody investigated that. The other interesting thing about the shootout, although we're kind of rolling back here, was that it only lasted about 10 minutes. So these 2 agents are coming onto the reservation. They claim to serve a warrant for a young man named Jimmy Eagle. Now, Jimmy Eagle is wanted for stealing a pair of cowboy boots. Now, to get that, there was an assault and battery that's related to taking the cowboy boots. Basically, what you had was a fight between Jimmy Eagle and guys that he were friends with, some cowhands in the area. They got in a fight, and Jimmy stole the boots. Not really something the FBI investigates. So they radio in. We're following a red pickup truck, fits the description of Jimmy Eagles, we're going to get him. Then they also radio in, wait, the truck is stopping. The people are getting out. They're shooting at us. We need help. That whole process lasts about 10 minutes. We know that Peltier wasn't in that truck because all the witnesses put him hundreds of yards away at a ranch house. So we know he's not in the truck. But whoever shot the agents is in the truck. That lasts about 10 minutes. Within 10 minutes, though, within that time frame, 100 to 150 agents and private militia show up in support of these 2 agents. Now, look, I had some cases where law enforcement puts together a group to go serve a warrant, or you've got some kind of situation that takes hours, if not days. There's no way that you pull together 100 to 150 agents, armed agents involving helicopters, and get to this spot without knowing that it was going to happen. He knew it was going to happen. They sent those agents in there and got them killed.
So at the end of the day, the explanation is that the FBI is a family. They circled the wagon, so to speak, and they were going to protect their own one way or another, despite the evidence, despite the law, despite the Constitution, despite the overwhelming evidence to the contrary. They were going to stick with their narrative, and they were going to say whatever they needed to say to keep them in jail.
I think that's right. I mean, it's that simple, and I'm not a conspiracy theory guy, and it's really not hard to understand that, right? They've got somebody. We're moving on. This is our guy, and never mind that your other two you indicted who were with him were acquitted based on self-defense.
But it's even more extraordinary than that, isn't it? Because the FBI could have taken the position, the humane position, that said, look, we still believe he's the one who shot these FBI agents, but he has served 50 years in jail, and he's ill. He's how old now?
Now he's 80.
He's 80. He was released when he was...
right at 79.
79. He's been out for about a year, and we'll talk more about that in a minute. But he's 79 years old. He's got serious health problems. He may not live a few more years. As a humane gesture, we'll let him out. But they were unwilling, unable to even say that.
No, that's right. I think it's back to this. They don't care. They don't see them as human beings. There's us. We are law enforcement. We are the protectors. However that has to happen. And then there's the rest of them. And we see that today, right? We see that with ICE today, right? It's us versus them. Those people are seen as less than human. That 5-year-old boy we saw on television the other day in ICE custody, right? You don't do that to a child unless you don't think of them as human. They're less than you. I can do that to you. I can grab the people out of their homes and throw them half naked into the snow because you're not a human being.
And now ICE has taken the position, just as a brief detour, that they can enter homes without a warrant.
Right. And they can do that because you aren't, as you know, Native Americans weren't for a long time. They weren't citizens protected by the Constitution. And ICE, I think their mentality is, what Constitution? There is no protection for you. Our job is to come drag you out of your homes and send you back. Never mind that you may actually be a U.S. citizen. Never mind that you're a child.
Our firm gets involved. We represent Peltier. You're the lead lawyer for Leonard Peltier for years. How did it come about that we were successful in getting him released on the last day of President Biden's term?
Well, I think this is interesting. It's part of how did we put this story together and get them to keep him on the radar and get Biden's attention, because even with Biden's affinity and understanding of Native American issues, this was still a heavy lift. It's still one heavy rock in this quarry. But one of the things we were able to do that had not been done in the past, and I didn't do this, certainly not alone, was pull together the Native American communities like they had never been before. There are 700 plus tribes in this federally recognized tribes in this country, and they had often been split. Some not because they didn't understand the issue or think that he was innocent or never should have been convicted, but it just wasn't their problem, right? So you had large tribes like the Navajo and Cherokee, and some of the Plains tribes were always there, but some who this wasn't our problem. They all came together like never before. You also had Deb Haaland, who was Secretary of the Interior, Native American. You had a lot of Native Americans throughout the administration. And right at the end, we knew this was it. There was, no matter who won this election, it was going to be at least another 4 years, if at all, and he was not likely to survive. They all came together, but so did the Catholic Church. The Catholic Church had always been supportive of Leonard Peltier, but not in the way that Pope Francis was. And Pope Francis had a relationship with President Biden that popes and presidents had never had before. And so we got right down to the end, and I got the phone call that said, what do we need? What's left for us to do? And we're covering all the bases. And I said, can the Pope make a phone call? Make another phone call. We need him. And they went, it's 3:00 in the morning. I went, can somebody wake up the Pope and have him make a phone call? And my understanding is somebody went and woke up the Pope, and the Pope made a phone call and came in and advocated on behalf of Leonard Peltier. And, putting that, could that have done it alone? Probably not. But putting that with all of the voices from the Native American community, all of the civil rights communities, all of the just normal, mainstream people.
And including those voices, of course, is Stevie Van Zandt. So you
Van
have a
Zandt.
connection between the Pope, Stevie Van Zandt, and Leonard Peltier.
Yeah,
Tell us about that.
And so Stevie was there. Sometime during this process, I got an email that said, hey, I understand you're Leonard Peltier's lawyer. Give me a call. And I emailed him back thinking, I'm not sure this is Stevie Van Zandt, but okay, I'll email him back. And I emailed him, goes, look, I'll have my people get in touch with your people. And he goes, and he emailed me back and goes, this is my cell phone, just call me. And so I called Stevie, and we worked really closely together. Stevie has always been a Peltier supporter, but he was re-energized by what we were doing and how we were doing it. And, he used all of his influence, and he had connections inside the Biden administration and became involved.
So a lot of great people came together and got it done on the very last day of the administration. It was nail-biting time, wasn't it?
It was, because I'm watching on television, I'm watching the inauguration. Now I'm getting phone calls that tell me he's going to sign it. I'm thinking back, yes, so did Leonard's lawyer when Bill Clinton was president, that it was going to be signed. And I don't have any word that it's been signed. And I'm watching the inauguration, and I see, President Biden come walking into the frame. I'm thinking he didn't do it. I don't have word, and he's not in his office to sign this thing. And turns out that he had signed it either earlier in the day or the night before it had been signed. And then they released it and sent me a copy of it. We knew that Leonard was free.
It is a great story. It's a great story in so many ways, but it also, for me, most significantly with respect to you, reflects your passion, your commitment. This is something that you were involved in, as you were with Chris Young, for years, against all odds, doing things that no one else had done before. People had tried before and didn't get it done. You got it done, and I want to congratulate you for that.
Thank you. It was a team effort, though. I mean, it really took all of there were a lot of lawyers in this firm who worked on, a lot of people who wrote papers, who wrote letters, who coordinated with influencers to get this done. This doesn't get done with me alone. And I only came in some ways, I feel like the field goal kicker who comes in and kicks the field goal and gets to win the game. But it's because for 4 quarters, this thing was really close. And people have been working on this for 5 decades.
And missing field goals and doinking it against the crossbars. You didn't doink it, you didn't miss it.
We didn't, and we didn't give up. It ain't over till it's over. And, there were a lot of people who just went, Kevin, we're in year 5. What are we doing? We're not giving up. Let's step back and rethink this. What do we need to do? We have a different president. We have different supporters. Let's repackage this again. The presentation we made to the Trump administration was very, very different than the presentation we made to the Biden administration. The story was the same. The facts are the same. But how do you package that? How do you present that narrative in a way that somebody understands it? Back to the way Chris Young packaged his story to me. Does that work for somebody else? I don't know. But he told that story to me, and it changed my life. I wanted to tell Leonard's story in a way that was going to change his lives and change the lives of people who listened to the story.
Yeah.